not yet convicted by final judgment, he cannot be considered as a quasi-recidivist. It cannot be considered as an aggravating circumstance. When you say degree of penalty, it refers to the penalty prescribed by law for every felony and the penalty imposed by the court in case of conviction. When you say period of penalty, it refers to the subdivision of a divisible penalty into 3 periods. The first 1/3 period is known as the minimum period. The second 1/3 portion is known as the medium period. And the third 1/3 portion is the so-called as the maximum period. When you say indivisible penalties, these are penalties which have no fixed duration. Under the RPC, the following are considered as indivisible penalties: death penalty, reclusion perpetua, perpetual absolute disqualification, perpetual special disqualification, public censure. All of these have no fixed duration, and all of these cannot be divided into minimum, medium, and maximum periods. But isn't it that reclusion perpetua under Article 27 as amended by RA 7659 now has a fixed duration of 20 years and 1 day to 40 years? The Supreme Court said that in the case of People v. Lucas and other cases, the Supreme Court said that even if under Article 27 as amended by RA 7659, reclusion perpetua now has a fixed duration, it remains to be an indivisible penalty. Supreme Court said there is nothing in RA 7659 which shows that Congress has the intent to alter the designation of reclusion perpetua from indivisible to divisible. Hence, it remains to be an indivisible penalty. Therefore, whenever reclusion perpetua is imposed, the court need not state the duration. On the other hand, those penalties which can be divided into minimum, medium, and maximum are the so-called divisible penalties. Under Article 63, the law provides for the rules for the application of indivisible penalties. Under Article 63, the following are the rules for the application of indivisible penalties. First, when the penalty prescribed by law is a single indivisible penalty, it shall be imposed regardless of any mitigating or aggravating circumstances. Second rule, if the penalty prescribed by law consists of 2 indivisible penalties, you observe the following rules. If there is one aggravating circumstance with no mitigating circumstance, the greater penalty shall be imposed. Second, if there is only one mitigating circumstance with no aggravating circumstance, the lesser penalty shall be imposed. Third, if there are no mitigating, no aggravating circumstance that attended the commission of the crime, the lesser penalty shall be imposed. And lastly, if there are both mitigating and aggravating circumstances attendant in the commission of the crime, offset the two and apply the rules I previously mentioned. These are the rules for the imposition of indivisible penalties under Article 63. Under Article 64, on the other hand, the law provides for the rules for the application of penalties in divisible penalties. And under Article 64, the following are the rules for the application of divisible penalties. If the commission of the crime is not attended by any mitigating or aggravating circumstance, the penalty shall be in its medium period. If the commission of the crime is attended only by a mitigating circumstance with no aggravating circumstance, the penalty shall be in its minimum period. If the commission of the crime is attended only by an aggravating circumstance with no mitigating circumstance, the penalty shall be in its maximum period. If there are both mitigating and aggravating circumstances, you offset the two and then apply the rules. Fifth rule, if there are 2 or more mitigating circumstances with no aggravating circumstance, you lower the penalty by 1 degree in its proper period. If there is a privilege mitigating circumstance, apply it first before computing the penalty. Whenever we talk of Article 64, the rules for the application of divisible penalties, you have to consider Act 4103 as amended or the indeterminate sentence law. The indeterminate sentence law is the law that modified the imposition of penalties both under the RPC and under special penal laws. Under the indeterminate sentence law, it is provided that the moment the said offender has already served the minimum term of the sentence, he becomes eligible for parole. So, the said indeterminate sentence law mandates courts that in imposing a penalty, there must be a maximum term of the sentence and a minimum term of the sentence. So that the moment the accused had already served the minimum term of the sentence, he would become eligible for parole. Once he is released based on parole, it doesn't mean that he is totally a free man, because he has still to report to the parole officer depending on the conditions attaching to the grant of parole. So what are the conditions for one to be granted parole? First, it is necessary that he must be serving an indeterminate sentence in a penal institution. Second, it is also necessary that he has already served the minimum term of his sentence. And lastly, the Board of Pardons and Parole finds that his release will not be inconsistent with the interest and welfare of the state, as he will be a law-abiding citizen. If these are present, he may become eligible for the grant of parole. Although the indeterminate sentence, or the purpose, of the indeterminate sentence law, its objective is to uplift and redeem valuable human material and prevent deprivation of liberty. Continuous deprivation of liberty. Bar question, how is this objective achieved? This objective is achieved because the moment the said convict has served the minimum term of the sentence, he now becomes eligible for parole. So, there is no prolonged deprivation of liberty. Although the indeterminate sentence law applies to all offenders and for all offenses, there are certain persons who are disqualified to be given an indeterminate sentence. How would you distinguish an indeterminate sentence from a straight penalty? An indeterminate sentence is one which has a maximum term of the sentence and a minimum term of the sentence, such that the moment the offender has served the minimum term of the sentence, he becomes eligible for parole. A straight penalty, on the other hand, has no maximum term of the sentence and no minimum term of the sentence. Therefore, the offender must serve the total penalty imposed on him. There is no way that he could be released for parole because there is no minimum term of the sentence. And under Act 4103 as amended, the following persons are disqualified to be given an indeterminate sentence. Therefore, they cannot avail of the benefit of parole. First, those who have been convicted of crimes punished by death, life imprisonment, or reclusion perpetua. Those who have been convicted of treason, conspiracy, and proposal to commit treason. Those who have been convicted of misprision of treason, rebellion, sedition, espionage. Those who have been convicted of piracy. Those who are habitual delinquents. Those who have escaped from confinement or evaded the service of their sentence. Those who, having been granted conditional pardon by the Chief Executive, shall have violated the terms of the said pardon. And lastly, those whose maximum term of imprisonment does not exceed 1 year. All these persons cannot be given an indeterminate sentence. Therefore, they cannot be released based on parole. X was convicted. He was convicted of murder. The penalty imposed on him is reclusion perpetua. Can he avail of the benefit of parole? No, he is disqualified. If he is convicted of the crimes mentioned, we have treason, conspiracy and proposal to commit treason, rebellion, sedition, espionage, piracy. He cannot avail of the benefit of parole because the penalty to be imposed on him is not an indeterminate sentence. If X has been convicted of a crime, during riot, he saw an opportunity to escape. He left the penal institution. Thereafter, he was arrested. And so, he was charged with evasion of service of sentence under Article 157. What is the effect of such escape on the penalty to be imposed on him in evasion of service of sentence? The judge cannot impose on him an indeterminate sentence. It must be a straight penalty because he cannot avail of the benefit of parole. X has been convicted by final judgment based on some mediators. The president granted him conditional pardon. He violated, so he was released. He violated one of the conditions attached to the said grant of conditional pardon. What is the effect on his criminal liability? He will be charged with evasion of service of sentence under Article 159. And the penalty to be imposed on him cannot be one which is indeterminate because he is among those excluded, disqualified. If the penalty imposed on the said offender, if the maximum period does not exceed 1 year, he cannot be given the benefit of parole. He is among those disqualified. How do you compute the indeterminate sentence? First, you get the maximum term of the sentence. In order to get the maximum term of the sentence, you take into consideration the penalty prescribed by law and the presence of mitigating and aggravating circumstances in accordance with the rules provided for under Article 64. After getting the maximum term of the sentence, you get the minimum term of the sentence by lowering the penalty by 1 degree. In lowering the penalty by 1 degree, in order to get the minimum term of the sentence, you no longer consider the presence of mitigating and aggravating circumstance. You only consider the penalty prescribed by law. That is in case of violations of the revised penal code. In case of violation of special penal law, in order to get the maximum term of the sentence, the judge can impose any penalty which shall not go beyond the maximum penalty prescribed by law. And to get the minimum term of the sentence, the judge can impose any penalty which shall not be lower than the minimum penalty prescribed by law. So we go first to Article 63. Go first to Article 63. Let us say that the crime committed, we have the rules for the application of indivisible penalties. Let us say that the crime committed by the offender is say that the crime committed by the offender was charged with the crime of rape. And based on the said information, the act of rape was committed by the offender in the dwelling of the victim. And it was also committed at night time. The offender deliberately sought the cover of darkness to ensure the commission of the crime. So it was attended by 2 aggravating circumstances. Both were proven in court. It was also proven that the said offender voluntarily surrendered. So there's one mitigating circumstance. The penalty for rape is reclusion perpetua. If you were the judge convicting the accused, what penalty would you impose? You have to impose the penalty as prescribed by law, reclusion perpetua. You do not consider any mitigating aggravating circumstances because based on the first rule under Article 63, if the penalty prescribed by law is a single indivisible penalty, it shall be imposed regardless of mitigating and aggravating circumstances. So you do not consider these circumstances because the penalty prescribed is a single indivisible penalty. But what if the crime committed, the penalty prescribed by law consists of two indivisible penalties? So, the accused was charged with a crime of murder. The penalty for murder is reclusion perpetua to death. Both are indivisible penalties. And let us say that the said act of murder, the said act of killing, the victim was killed by the accused while the victim was inside the house. While he was at the window, looking at the surroundings, the accused fired from the outside. Therefore, there was the presence of dwelling as an aggravating circumstance. And there is no mitigating circumstance. If you were a judge convicting the accused of murder, what penalty would you impose? Under Article 63, the greater penalty, and that is death penalty. Because the penalty prescribed by law consists of two indivisible penalties, if there is one aggravating circumstance, the greater penalty shall be imposed. But what if the commission of murder was attended by a mitigating circumstance? The offender felt sorry for what he had done, and so the offender voluntarily surrendered. So we have one mitigating circumstance, and there is no aggravating circumstance. If you were the judge convicting the accused, what penalty would you impose? The lesser penalty, which is reclusion perpetua. Because there's one mitigating with no aggravating. But let us say the commission of murder was not attended by any mitigating and aggravating circumstances. No. If in the problem treachery is present, you do not consider it because treachery is the one that makes it murder. Treachery is the qualifying circumstance that makes it murder and not homicide. Therefore, it should not be considered in the imposition of penalty. Let us say that in the act of murder, there is no mitigating and no aggravating circumstance. What penalty would you impose? Based on Article 63, the lesser penalty, therefore, reclusion perpetua. What if, in the commission of the said murder, there are both mitigating and aggravating circumstances? So here, murder was committed in the dwelling of the victim. So we have one aggravating circumstance. And the offender voluntarily surrendered. We have one mitigating circumstance. So the commission of the crime was attended by both mitigating and aggravating. If you were the judge convicting the accused, what penalty would you impose? The law provides, if they are both aggravating and mitigating, you offset the two. So you offset dwelling, a generic aggravating, with voluntary surrender and ordinary mitigating. Therefore, after offsetting, there are no more modifying circumstances. The lesser penalty, reclusion perpetua, shall be imposed. But what if the crime committed instead of murder is homicide, which is punished by reclusion temporal, a divisible penalty? This is punished by reclusion temporal. Reclusion temporal is a divisible penalty. So now, it is no longer Article 63 that is applicable. It is now Article 64 in relation to the indeterminate sentence law. Because whenever you talk of divisible penalties, you have to always consider the indeterminate sentence law, Act 4103 as amended. So let us say that in the commission of homicide, the accused was charged with homicide, no aggravating circumstances alleged in the information, and no mitigating circumstance. The judge found him guilty beyond reasonable doubt. What penalty would you impose as the judge? So you take into consideration, you first get the maximum term of the sentence, you take into consideration the penalty prescribed by law, which is reclusion temporal, and the attendant mitigating and aggravating circumstances based on the rules provided for in Article 64. Under Article 64, when there are no aggravating, no mitigating, the penalty shall be in its medium period. So we have here reclusion temporal in its medium period. This is the maximum term of the sentence. To get the minimum term of the sentence under the indeterminate sentence law, you lower the maximum penalty from 1 degree, by 1 degree. So what is the penalty lower? By 1 degree from reclusion temporal, it will be prisión mayor. And under the indeterminate sentence law, the range of the minimum term of the sentence depends on the sound discretion of the court. Therefore, you do not have to determine the presence of aggravating and mitigating circumstances in determining the period of the minimum term of the sentence, because this depends on the sound discretion of the court. So, based on the sound discretion, since this is medium, let us make this also medium. But again, it depends on the sound discretion of the court, so the court can make this minimum, medium, or maximum, depending on the court. This is now the minimum term of the sentence. After the convict has served this behind bars, he becomes eligible for parole. This is an indeterminate sentence. It has a maximum term and a minimum term of the sentence. Let us say that in the commission of the crime of homicide, it was attended by one mitigating circumstance. Let us say that he killed the victim because of sudden impulse of passion and obfuscation. So we have here one mitigating circumstance. There is no aggravating circumstance that attended the commission of the crime. What penalty shall be imposed? Under Article 64, if there is one mitigating with no aggravating, the penalty shall be in its minimum period. So we have here reclusion temporal in its minimum period. This is the maximum term of the sentence. Same procedure to get the minimum term of the sentence. You lower it by 1 degree. The range depends on the sound discretion of the court. So we have here prisión mayor. This is the minimum term of the sentence. But what if in the act of killing, it was attended by one aggravating with no mitigating? Let us say that the aggravating circumstance present is, let us say, nighttime. So we have one aggravating circumstance with no mitigating circumstance. What shall be the maximum term of the sentence? Under Article 64, if there is one aggravating with no mitigating, the penalty shall be in its maximum period. So we have here reclusion temporal maximum. That is the maximum term of the sentence. To get the minimum term of the sentence, again, same procedure. You lower it by 1 degree. The penalty or the range depends on the sound discretion of the court. But what if homicide was attended by both mitigating and aggravating circumstances? So we have, let us say, it was committed at night time, and it was the offender voluntarily surrendered. So we have one aggravating, one mitigating circumstance. What do? under Article 64, you offset the two and apply the rules. So you can offset 9 times a generic aggravating with voluntary surrender and ordinary mitigating. After offsetting, there are no more modifying circumstances, therefore the penalty shall be in its medium period. So we have here reclusion temporal in its medium period. That is the maximum term of the sentence. Again, to get the minimum term of the sentence, you lower it by 1 degree. The range depends on the sound discretion of the court. But what if the commission of the crime of homicide was attended by 2 mitigating circumstances with no aggravating circumstance? So let us say that the act of killing was based on sudden impulse of passion and obfuscation. So we have this impulse of passion and obfuscation. And the offender also voluntarily surrendered. So we have 2 mitigating circumstances. And there is no aggravating circumstance. How would you get the penalty? Under Article 64, 5th rule, when there are 2 or more mitigating with no aggravating circumstance, you have to lower the penalty by 1 degree. Here, we have 2 mitigating circumstances of sudden impulse of passion and obfuscation and voluntary surrender with no aggravating. Therefore, you have to lower the penalty by 1 degree. 1 degree from reclusion temporal is prisión mayor. You have already considered all modifying circumstances, therefore the penalty shall be in its medium period. This is the maximum term of the sentence. To get the minimum term of the sentence, again, lower it by 1 degree. Prisión mayor, 1 degree lower is prisión correccional. And again, the range depends on the sound discretion of the court. Since this is medium, let us also make this as medium period. And this is the minimum term of the sentence. But what if there are 3 mitigating with no aggravating circumstance? So let us say, aside from sudden impulse of passion, obfuscation, and voluntary surrender, there was also the mitigating circumstance proven to be praeter intentionem. He has no intention to commit so grave a wrong as that committed. So we now have 3 mitigating circumstances with no aggravating circumstance. What penalty would you impose on the said offender? The law requires when there are 2 or more mitigating with no aggravating, you lower the penalty by 1 degree. So here, we lowered it by 1 degree. It is now prisión mayor. The law only requires 2 mitigating with no aggravating. There remains to be 1 another mitigating. What is the effect of this 1 remaining mitigating? The penalty shall be in its minimum period. So we have prisión mayor in its minimum period. This is again the maximum term of the sentence. To get the minimum term of the sentence, same procedure, you lower it by 1 degree. But what if there are 4 mitigating with no aggravating? So let us add another one. Let us say that at the time he was intoxicated, which is not done habitually and not intentional prior to the commission of the crime. So now we have here 4 mitigating circumstances. What is the effect? There are 4 mitigating with no aggravating circumstance. Under Article 64, the law only requires 2 mitigating with no aggravating to lower the penalty by 1 degree. So there are 2 mitigating with no aggravating, we lower it by 1 degree. But there remains 2 more mitigating circumstances. Do you have to lower it by another degree? You cannot lower it by another degree. That shall be applied only once. So what about the fact that there are 2 others mitigating circumstances? The presence of the two other mitigating circumstances would only mean the penalty shall be its minimum period. But you can never lower it by another degree, so this will be prisión mayor minimum period. That is the maximum term of the sentence. Again, to lower it, to get the minimum term of the sentence, you have to lower it by 1 degree. What if, in this problem, let us say that let us say that the offender who committed the crime of homicide, attended by the mitigating circumstances of sudden impulsive passion, obfuscation, voluntary surrender, greater intention, intoxicated, and no aggravating, happens to be a minor. He was 17 years old and he acted with discernment. Therefore, minority is a privileged mitigating circumstance. How do you get the penalty? Whenever there is a privileged mitigating circumstance, you apply it first before computing the penalty. And the effect of minority as a privileged mitigating circumstance, you lower the penalty by 1 degree under Article 68 of the RPC. Therefore, from reclusión temporal, it will become prisión mayor. So you have already applied minority. Now, there are 4 mitigating with no aggravating. What is that? Under Article 64, when there are only 2 mitigating and no aggravating, you lower the penalty by 1 degree. So we now have here prisión correccional. You only need 2. There are 2 remaining, so it will be prisión correccional in its minimum period. Then we have, how do you get the minimum term of the sentence? This is the maximum term of the sentence. How do you get the minimum term of the sentence? Again, you lower it by 1 degree, it will become arresto mayor. So that will be the minimum term of the sentence. But what if in the first problem that I gave, that is the crime of rape, what if the act of rape was committed by a minor? The act of rape was committed by a minor. The penalty for rape is reclusión perpetua. So earlier I said the crime was attended by dwelling as an aggravating circumstance. And then it was also attended by nighttime as an aggravating circumstance. And there is voluntary surrender. So we have 2 aggravating. And then we have 1 privileged mitigating circumstance of minority. So we have this privileged mitigating circumstance. Whenever there is a privileged mitigating circumstance, it must first be applied before computing the penalty. But this is single indivisible. Can you still lower the penalty because of the presence of privileged mitigating circumstance, even if it is a single indivisible penalty under Article 63? If there is a privileged mitigating circumstance, you still have to lower it by 1 degree. So from reclusión perpetua, an indivisible penalty, because of the presence of the privileged mitigating circumstance of minority, you lower it by 1 degree. It is now reclusión temporal. From an indivisible penalty, wherein Article 63 is applicable, it is now a divisible penalty, wherein Article 64, in relation to the indeterminate sentence law, is now the one applicable. So now here, the said minor is now entitled to an indeterminate sentence. What if the offender, the accused, was charged with one count of homicide, and 3 counts of frustrated homicide. And for after the judge, the accused was charged with one count of homicide and 3 counts of frustrated homicide. After trial on the merits, the judge convicted the accused as charged, 1 count of homicide and 3 counts of frustrated homicide. And for the homicide, the judge imposed the penalty of 15 years, a maximum of 15 years imprisonment. In frustrated homicide, maximum of 10 years imprisonment. How shall the convict serve these multiple sentences? He was given multiple sentences. How shall he serve the multiple sentences? If a convict is imposed with multiple sentences, the law provides he shall serve them simultaneously. That is, if the nature of the penalty allows simultaneous service of sentence. And what are these penalties which allow simultaneous service of sentence? Imprisonment and fine, imprisonment and suspension. We have also imprisonment and disqualification. They can be served at the same time. Desterro and fine, they can be served at the same time. But if the penalty imposed by the court are all imprisonment behind bars, they cannot be served at the same time. They cannot be served simultaneously. So, under Article 70, they shall be served successively. However, there is a limit in the successive service of sentence, and that is the so-called threefold rule. Under the so-called threefold rule, the maximum duration of a convict sentence shall not exceed 3 times the length of the most severe penalty, but in no case to exceed 40 years. So here, let us say that we will not apply the threefold rule. So we have here 15 years, 10 years, 10 years, and 10 years. So he will be serving 45 years. That is, if you will not apply the threefold rule. Let us apply the threefold rule. The maximum duration of a convict sentence shall not exceed 3 times the length of the most severe penalty. So what is the most severe penalty? 15 years. 15 years times 3. We have 15, same, 45. Is he going to serve 45 years? No, because there is another limitation. It must not exceed 40 years. Therefore, for having been convicted of the crimes of homicide and 3 counts of frustrated homicide, the judge, or he shall only be serving the sentence of 40 years imprisonment. This is taking into consideration the so-called threefold rule. So what if the father was charged of the crime of 5 counts of rape? So the father was charged with The father was charged with 5 counts of rape by the daughter. After trial on the merits, the judge convicted the father as charged. And the judge, the dispositive portion of the said decision stated that finding the accused guilty beyond reasonable doubt of 5 acts of rape done against the daughter, he is hereby sentenced to suffer the penalty of 40 years imprisonment, taking into consideration the threefold rule, and to pay the victim civil indemnity in the amount of 50,000 pesos. Is the judgment of the court correct? That has been given many times in the bar recently. Is the judgment of the court correct? The judgment of the court is wrong. The threefold rule refers to service of sentence. Therefore, it is not for the judge. It is not for the court to apply, to impose. It is for the director of prisons to compute. The judge is mandated by law to impose the penalty prescribed by law for every crime committed. Therefore, the penalty should be the penalty of reclusion perpetua for each count of rape. That should be the penalty imposed by the court. How about the civil indemnity imposed by the court? Is it correct? The civil liability imposed by the court is also wrong. Supreme Court said, every act of rape is a violation of the human dignity of the said woman. Therefore, for every act of rape, even if the victim is one and the same, there is a corresponding civil indemnity. Therefore, in its judgment, the judge must state that he shall impose on the said accused the civil indemnity of 50,000 pesos for each count of rape. So that is the proper judgment because, again, the so-called threefold rule is not for the judge to apply, but for the director is also. Related to the revised penal code is, sabi nyo, hindi pa na-discuss, probation law. So, probation law, PD 968, has been amended by RA 10707. Probation is a disposition after which the convict, after having been sentenced, may be granted liberty by the court based on the period and the terms subject to the conditions of the court. The moment a person has been released based on probation, it doesn't mean that he is a totally free person. He still has to report to the probation officer depending on the terms attaching to the grant of probation. The following are the purposes of probation. First, to provide for the reformation of the said offender. Second, to give the said offender opportunity to reform. Third, to prevent further commission of crimes. Fourth, to decongest the jails. Fifth, to save the government that much needed funds which would be incurred if he is placed behind bars. These are the different objectives, purposes of probation. Probation is not a matter of right. Probation is a privilege. Under the probation law, there are certain convicts who are disqualified to avail of the benefit of probation. But even if the offender is not among those disqualified to avail of the benefit of probation, if the court, upon application for probation, deems it proper to deny his application for probation, then so be it. Under Section 4 as amended by RA 10707, an application for probation or an order granting or denying an application for probation is not appealable because the grant or denial of an application for probation depends on the sound discretion of the court, of the judge, because again, probation is not a matter of right, but a matter of privilege. Under Section 9 of PD 968 as amended by RE 10707, the following persons are disqualified to avail of the benefit of probation. First, those sentenced to serve a maximum term of imprisonment of more than 6 years. Second, those who have committed any of the crimes against national security. Third, those who have been previously convicted by final judgment of an offense punished by imprisonment of more than 6 months and 1 day or a fine of more than 1,000 pesos. And lastly, those who have been once on probation, because probation can be availed of only once. These are the persons disqualified to avail of the benefit of probation under RA 10707, amending PD 968. The accused was convicted. The maximum penalty imposed on him is that of prisión mayor. Can he avail of the benefit of probation? He cannot. Because prisión mayor is from 6 years and 1 day to 12 years. And the probationable penalty is 6 years and below 6 years. Therefore, he cannot avail of the benefit of probation. X was convicted of the crime of inciting to war and giving motives for reprisals. After conviction, he applied for probation. Can he avail of the benefit of probation? Must the judge grant the application for probation? No, because he is among those disqualified. Because inciting to war and giving motives for reprisal is a crime against national security under Title I of Book 2. Therefore, he cannot avail of the benefit of probation. X was charged with alarms and scandals. He was convicted by the court. He applied for probation within the period for perfecting an appeal. If you are the judge, would you grant the application for probation, or is he disqualified? Under this new law, amending PD 968, he is no longer disqualified. This was as 2013. At that time, he is disqualified. Because at that time, the law was still PD 968. And under PD 968, those convicted of crimes against national security and public order are disqualified. But in this new law, RA 10707, the word public order has been deleted. Therefore, only those convicted of crimes against national security cannot avail of the benefit of probation. If the offender has been previously convicted by final judgment of any crime wherein the penalty is more than 6 years, is more than 6 months and 1 day, he cannot avail of the benefit of probation. Or a fine of more than 1,000 pesos, he cannot avail of the benefit of probation. Or the moment he had been once placed on probation, he cannot again be placed on probation. It can be availed of only once. What if X was charged with a crime of attempted homicide before the Metropolitan Trial Court? So he was charged with a crime of attempted homicide. After trial on the merits, the judge found him guilty beyond reasonable doubt of attempted homicide and imposed upon him the penalty of 6 years, maximum of 6 years imprisonment. That is, prisión correccional. He is not satisfied with the judgment of the court. And so what he did, he appealed to the appellate court. He appealed to the Court of Appeals. The Court of Appeals, however, affirmed his conviction for attempted homicide and modified the penalty. The Court of Appeals imposed only a penalty maximum of 4 years. Can X go back to the trial court and apply for probation? X cannot go back to the trial court and apply for probation. Under Section 4 of PD 968 as amended by RA 10707, the moment a person has been imposed with a probationable penalty and he applies for probation or he appeals his judgment of conviction, such appeal bars his application for probation. Under Section 4, under Section 4 as amended by RA 10707, no application for probation shall be entertained or granted the moment the defendant has perfected an appeal from a judgment of conviction. Here, he appealed to the appellate court. The said penalty is already a probationable penalty. Instead of applying for probation, he still appealed to the appellate court. Therefore, he loses the right, the privilege to apply for probation. His appeal bars probation. What if the accused was charged with a crime of frustrated homicide? After trial on the merits, the judge found him guilty beyond reasonable doubt of frustrated homicide. And so, he appealed to the Court of Appeals, insisting on his innocence. Upon review of his case, the Court of Appeals affirmed the conviction but downgraded the crime only to attempted homicide and imposed a maximum penalty of 6 years. In the RTC, the maximum penalty imposed was 8 years. So it is a non-probationable penalty. He appealed to the CA, insisting he is innocent, but the CA affirmed the conviction, but downgraded the crime only to attempted homicide, and the CA imposed a maximum penalty of 6 years. X wanted to go back and apply for probation before the trial court. May X go back to the trial court and apply for probation? X may go back to the trial court and apply for probation. Under Section 4 of PD 968 as amended, it is provided that if a judgment imposing a non-probationable penalty is appealed, and the said judgment has been modified by the appellate court with the imposition of a probationable penalty, the said accused can go back to the trial court and apply for probation based on the modified decision. Here, the CA modified the decision. From frustrated, it becomes attempted. From 8 years maximum, it becomes 4 years maximum. It is now a probationable penalty. He can be given the right to go back to the trial court and apply for probation. Where shall he apply the probation? He can file the application for probation either before the court that sentenced him with conviction or before the other court wherein it was re-raffled. What if in the same problem, X was charged with a crime of frustrated homicide, convicted as charged, the RTC imposed a maximum of 8 years, he appealed to the Court of Appeals, the Court of Appeals confirmed the conviction but modified it by downgrading the crime only to attempted homicide and imposed a maximum penalty of 4 years. Still, insisting on his innocence, X appealed further to the Supreme Court. The Supreme Court, upon review of the case, affirmed in toto the decision of the CA. Conviction for attempted homicide with a penalty maximum of 4 years imprisonment. Can he go back to the trial court and apply for probation? X can no longer go back to the trial court and apply for probation. Under Section 4 of PD 968 as amended by RA 10707, third paragraph, the law provides that this defendant loses the benefit of probation the moment he further appealed the modified decision already imposing a probationable penalty. The CA modified the decision and imposed already a probationable penalty. When he further appealed it to the Supreme Court, he loses the benefit of probation. Therefore, even if the Supreme Court affirmed the conviction only for attempted homicide, he can no longer go back to the trial court and apply for probation. What if in the said problem there are many accused? They acted as conspirators in the commission of the crime of frustrated homicide. So let us say that A, B, C, D, and E, 5 men, acted as conspirators in killing the victim. And so they were all charged for the crime of frustrated homicide before the trial court. The trial court convicted them as charged conspirators and imposed all of them with a maximum penalty of 8 years. All of them appealed to the CA. And the CA modified the decision, convicting these 5 accused only of attempted homicide and imposing a maximum penalty of 6 years. A, B, and C further appealed to the Supreme Court. But D and E no longer wants to appeal. D and E wanted to go back to the trial court and apply for probation. Can they do that even if A, B, and C had already appealed to the Supreme Court? Based on this amendatory law, yes. D and E, even if A, B, and C further appealed the conviction to the Supreme Court, D and E can go back to the trial court and apply for probation. All they have to do is to submit or file a written application for probation plus a certified true copy of the judgment of conviction. And the court shall decide whether or not to grant or to deny the said application for probation. So these are the rules as provided for in Section 4 of PD 968 as amended by RA 10707. Whenever a person is granted probation, there are 2 conditions. We have the so-called general conditions and we have general or mandatory conditions, and the other one is the so-called special or discretionary conditions. The general or mandatory conditions refers to the reporting to the probation officer. Usually it is once a month. And the other discretionary conditions, this actually depends on the sound discretion of the court, provided it is not restrictive of the liberty and reformation of the said probationer. In one case, a teacher was charged with a crime. He was convicted, and the penalty imposed on him was within the probationable penalty, and so he applied for probation. The court granted the application for probation, but it is stated therein that during the period of probation, which is for 2 years, he cannot teach. So one of the conditions for the grant of probation is that he is not allowed to teach during the period of probation of 2 years. Is the said discretionary or special condition valid? Supreme Court said no. Supreme Court said these conditions depends on the sound discretion of the court, provided they must not be restrictive of the liberty and reformation of the said probationer. Here, the fact that one of the conditions deprived the teacher of the right to teach, it will be restrictive of his liberty and reformation because the only work he knows is to teach. He will be deprived of his only livelihood. Hence, in that case, Supreme Court said that is not a valid condition imposed in the grant of probation.